Hi, good afternoon for everybody. It's a great pleasure to be here again at the floor. This is for me a very important plenary session, since the small claim or people who handle this kind of represented persons finally these programs are the one that they foster trust in judiciary. I have I am proud to present you the next speakers in the first term. They're going to do it together. It's a presentation that both of them are going to do it together. In the first term, I will present Joana Anicet. Joana Anicet is Fellow of the Institute for Court Management in the Small Claim Court Administrator and Lead of Court Communications at the Judiciary of Trinidad and Tobago. Her career includes almost 15 years of delivering court communication strategy and public education programs to audiences across the Caribbean region. Joana champions the broadened use of technology to engage with court customers through web and digital media platforms. As a certified court administration, Joana serves on the leadership team that will soon introduce the small claim court systems at Trinidad and Tobago. So next time, please an applause to Joana. Now is Joanne Richardson, that is a managing director with the National Center for State Courts International Programs Group. She's an experienced judicial and legal reform expert and educator specializing in justice sector institutional reform. Mrs. Richardson has over 25 years of experience in the US, Eastern Europe, and Eurasia, Latin America, and the Caribbean. She previously served as head of the field office for the Independent Judicial Commission in Bosnia, conducting legal and judicial reform. A lead expert and director of the large-scale rule of law reform initiative in Kosovo, she oversaw the implementation of multi-phased administration of justice reform project funded by USAID. She was investigated and prosecuted war crimes for the Office of the Prosecutor of the International Criminal Tribunal for the former Yugoslavia in The Hague. Her current portfolio includes overseeing a regional multi-country program to improve the effectiveness and efficiency of the Caribbean justice system. The floor is yours. Thank you very much.
Thank you. Good afternoon, everyone. On behalf of my co-presenter, Joana Anicet, I would like to extend my heartfelt thanks to IACA for the invitation to present at this prestigious conference, celebrating IACA's 20th anniversary. It is an honor to be a part of such a significant milestone and to present with other distinguished speakers and panel members. And thank you as well to our moderator, Judge Otamendi. I'd like to take a few minutes to show a short video. It's actually a teaser on the topic we are about to address in this session. So if you would indulge me.
Has decided to represent himself. Mr. Morris, you ready to proceed?
Yeah. Yes, sir. Just
Wherever you feel comfortable, sir.
okay. Would you please state your name for the record? Hi, Trevor Julian Morris. Thank you. And where do you currently reside? I live in Van Nuys, California.
Mr. Morris, what are you doing?
I'm representing myself, Your Honor.
Yeah, but this isn't the movie Bananas. Just sit there and tell your story.
I've never seen that movie. Okay. Well, in regard to the conditions at the factory, I have here some photos which clearly show chemical barrels that
Objection,
were not.
Your Honor. I believe he's showing you things that were not in evidence. I never received photographs of discovery from Mr. Sanders.
Then, I'm sorry, sir, they can't come into evidence. Besides that, what else would you like to present to the jury or discuss in front of the jury?
I guess I have no further questions.
Okay. Then you have further witnesses or further evidence?
No. I'm just saying, if he's not prepared, this is clearly his fault.
Thank you. Just by way of background of this video, this is actually not a real trial. This is a television series that's centered on a jury trial. The performers, the jury members, and the judge are actors. Except there's this one individual who is not aware that this is not a real case. So it's quite interesting. And for those of you who like to indulge in a bit of reality TV, it's streaming on Amazon. The name of the program is The Jury Duty. Humorous. Still, I think there are lots of lessons that we can learn from this video. By a show of hands, how many persons are from jurisdictions where litigants in person are not familiar with rules of procedures and evidence and could potentially face challenges such as the ones that you saw at a trial in a civil or criminal case? By a show of hands. And what about the role of the judge? Should the judge have exercised some discretion and some flexibility, given the fact that the litigants in person didn't have any legal experience or knowledge of the rules of procedure? Judges are faced with these dilemmas quite frequently in litigants in person cases. There has undoubtedly been an increase in self-represented litigants in the United States over the last 50 years. However, it is a common practice in many countries and the accepted norm in resolving cases. Very often, litigants in person, their matters account for a substantial number of the overall cases in lower courts. The International Bar Association highlighted a report showing the significance of the increase in litigants in persons in family law. These are attributed, the reason for the increase was the restricted access to legal aid. The report by the Law Society of England and Wales stated that thousands of litigants are representing themselves in divorce and separation cases due to a lack of access to attorneys. It also notes, ultimately, the increase in litigants in persons affects everyone's access to justice. It stated that the self-represented litigants lack proper advice, which means they cannot present their cases as effectively as possible. Additionally, their limited access to justice slows down the entire process for everyone. In other words, there is a direct correlation between litigants in persons or self-represented litigants, as commonly known, or pro se, as they are known in the United States. There's a correlation between these cases and case backlogs. Additionally, judges and court staff often face the challenge of balancing the need to provide assistance to litigants in person while ensuring the integrity and efficiency of the judicial process. With this evolving landscape, for the reasons I just stated and others, the Securing Access, Fairness, and Efficiency SAFE initiative was launched in Trinidad and Tobago. It is one of several capacity building and administration of justice programs conducted in partnership with Caribbean judiciaries under the Caribbean Anti-Crime Program. The core objective of the Caribbean Anti-Crime Program is to improve the effectiveness and efficiency of the Caribbean justice system. Here's a brief overview. You need to scroll down, okay? Can you play the video?
Introducing the SAFE project, securing access, fairness, and efficiency for litigants in person. Understanding and navigating the court system can be a challenge, especially for people who do not have an attorney at law and are representing themselves. In courts, these persons are called litigants, in person or self-represented litigants. From trying to understand legal words and how the courts work, to completing court forms and documents. For some, coming to court can be a daunting and discouraging experience. Errors made along the way can lead to miscommunication, backlogs in court cases, and other delays. The Judiciary of Trinidad and Tobago introduced a suite of electronic and online services for greater convenience and easy access to court services. The judiciary has also partnered with the United States government in July 2022 to implement the Securing Access, Fairness, and Efficiency Project, also known as SAFE. Led by the Caribbean Anti-Crime Program, funded by the U.S. Department of State Bureau of International Narcotics and Law Enforcement Affairs, INL, and the National Center for State Courts, the implementing organization of the Caribbean Anti-Crime Program. The SAFE project is designed to assist magistrates and high courts in the Caribbean to better serve litigants in person at court. In Trinidad and Tobago, the SAFE project will further improve court services by 1. Creating easy-to-understand multilingual material such as videos and infographics to help litigants in person better understand what is needed for their court matter and what happens in court. 2. Providing training to judges, judicial officers, court staff, and justice sector partners to help them better serve litigants in person. And 3. Providing additional tools and resources to assist litigants in person with navigating their way through the court system. To achieve these goals, the SAFE project is tailoring its efforts to meet the needs of the people of Trinidad and Tobago with insight from judiciary employees and other key justice sector stakeholders, including the Trinidad and Tobago Police Service, the Office of Director of Public Prosecutions, the Legal Aid and Advisory Authority, the Public Defender's Office, the Law Association, and the Children's Authority. Judges, judicial officers, and court staff will also be better equipped to provide litigants and persons with the support they need. The partnership between the judiciary and the SAFE project will help improve the efficiency of the court and will also promote the fair and transparent administration of justice for litigants in person. For more information on the SAFE project, visit the Judiciary of Trinidad and Tobago's website and social media channels. The SAFE project, securing access, fairness, and efficiency for litigants in person.
Thank you. So I'd just like to go back. That was a brief overview of the program. I'd like to go back to the blueprint, the strategy for implementing the SAFE initiative. As you can see and heard from the video, the blueprint for the SAFE project involved partnering with stakeholders to identify common challenges with litigants in person. We also developed comprehensive training programs, asynchronous and in-person, in collaboration with Judicial Education Institute of Trinidad and Tobago, to better equip judges and court staff as they preside over litigants in person cases. We developed resources such as explanatory videos and infographics, and you'll hear some more about that from my co-presenter, in order to communicate the critical information to litigants in person to increase efficiency and fairness. And last but not least, was conducting stakeholders sensitization public awareness campaigns, which is in progress in Trinidad and Tobago. And eventually, there will be a monitoring and evaluation aspect of the program to ensure that we are measuring the impact of the tools. So I'd like to invite my co-presenter, Shawnette Anisette, to take you through the tools of the SAFE initiatives. Shauna.
Good afternoon, everyone. And so, just as explained in the video, I'll take you through a little more the details of how we went about our methodology for the project and what we were able to achieve. And I'll do so very quickly because I'm getting the signs that they'll ring the bell on me just now. So in Trinidad and Tobago, we adopted a holistic approach to this project instead of just focusing on criminal justice. While a review of the data will tell you about the different case types and court services that are frequently accessed by litigants in person, our approach in Trinidad and Tobago acknowledges that this customer group, in fact, is present in significant numbers across all case types. Added to this perspective is that for us in Trinidad and Tobago, many of our main points of initiating interaction with this customer group are standardized across different divisions and service areas. So for example, whether you are a criminal court customer, a family court customer, or a civil customer, you are in many instances coming through the same door. You are in many instances accessing the e-filing portal from the same point. You are coming through our court pay and digital payment services from the same platform. And so for us, it made sense to develop content and material that targets all customers regardless of your case type. Also to say that in Trinidad and Tobago at this stage of the project, we had come some far way in developing different forms of services for self-represented litigants already. We have virtual access customer centers, customer contact centers, an e-filing portal, videos, etc. But many people were still not getting the information and understanding what was required of them in order to navigate court services. And so we embarked on the project, and as a first step, it was important for us to understand this customer group. We all know that the self-represented litigant is one who, whether by choice or without option, represents themselves in court proceedings. Through the work of this project, we have been able to define 5 main types of self-represented litigants in Trinidad and Tobago. So first, which is commonly accepted, is that customer who is unable to afford private legal representation. But there's another layer to that, which is we have persons who do not qualify for legal aid services while still not being able to access private legal representation. In Trinidad and Tobago, persons have to undergo a means test, and so in many instances, they do not make the point of eligibility. Also in Trinidad and Tobago, we have situations in which, for example, at the family court, a simple divorce case involving no children or property could range anywhere from $5,000 to $15,000. And so it really is a difficult situation for many persons. The pro se litigant is also one who believes that, this matter is not that complicated. I could totally do this on my own. And so we are seeing a new phase of a customer that is more empowered and engaged, and they feel like they can go on YouTube and watch a DIY video or tutorial. They can talk to ChatGPT, and ChatGPT will tell them how to engage with the courts. But still, where there are gaps, there is an expectation that the courts will support. We also have those who do not trust in services of attorneys. Not to be discounted is that in many instances, the self-represented litigants begin their court journey with an attorney, and somewhere along the line, they separate from that attorney, so to speak. We also have the customers who are not aware of the free or low-cost options for legal representation and conflict resolution. Other common characteristics: we have persons who, I'm sure as well in your countries, have limited understanding of legal language, or legalese as I call it, which leads to language barriers. We have persons with low literacy skills and other accessibility issues, such as hearing and visual impairments. But these persons are presenting before the courts with incomplete paperwork, incomplete forms, which is then resulting in a lack of preparation or sufficient knowledge in order for them to engage properly before the courts. This leads to confusion, fear, intimidation, and a lack of meaningful participation by the LIPs or self-represented litigants, as well as an inability or reduced capacity to understand what is happening in the matter. This leads to persons feeling excluded or isolated. And so for us in Trinidad and Tobago, our methodology had to apply a different approach. So instead of going to court customers, users, and the public to find out from them what are some of the things that they would want for us to address in our material, we felt it necessary to, at that time, collect data internally from our judges, judicial officers, and court staff, and also from justice sector stakeholders. This was a deliberate approach based at the time on the public climate and the need to arrive at a baseline to inform the project's goals without converging other issues of customer perception and a lack of public trust and confidence. And so I'm essentially saying, instead of going out to gather that data from the external audiences, from the people that will actually access those services, we took the choice at that time to look at the data that we currently have and the data that is held by our justice sector stakeholders. That then resulted in data that we pulled internally, as well as data that we received from 228 justice sector stakeholders, including representatives from the Director of Public Prosecution's Office, the Public Defender's Department, Legal Aid, the Trinidad and Tobago Police Service, as well as the Prison Service. The survey that we administered, including questions that fell into the following categories. We looked at data on case types and the courts in which self-represented litigants are frequently being served. We looked at the different services that are currently offered not only by the judiciary but by other justice sector stakeholders to support litigants in person. We looked at the challenges encountered by those customers at those points, and we also looked at training programs, wherever they existed, to guide stakeholders on the interactions with LIPs or self-represented litigants. The result, though, guided us to being very specific on prioritizing the topics and themes to be addressed immediately in the short term across the different case types. You can see on the screen some of the more frequently requested topics of data, which include divorce, child maintenance, probate, and aspects of the criminal justice system, including bail and plea agreements, for example. We also use the data to cue us in not only on the topics, but the types of material, because we can develop material in different forms. And so I'll now show you very quickly some examples of the tools and materials that we have developed. First is our self-help website, which was launched just a few weeks ago to provide a simple, easy to understand, easy to interact with design and interface on a web-based platform. This website is a stark improvement on our main website, which customers have said is quite difficult and tedious to navigate. All of the information from the project is based on this site, which will be further developed as we proceed. There is a QR code for you to check out the website if you would like to. Again, we're still in early stages, but it provides a very easy to access, easy to navigate interface for our customers. Yes, and this just shows you different aspects of the site. In terms of dissemination of material, we have focused on a social media campaign, which includes scheduled launches of different forms of material on our Facebook and Instagram pages. Although print material will also be developed, the use of digital media platforms allows us to track and monitor the effectiveness of and the impact of the material. We are also gathering data on customers' behavior patterns through our digital media platforms. It is still early days yet, but we are seeing a significant improvement on the engagement and reach metrics on our social media pages. This is a snapshot of what our material looks like. We have developed material in infographic format for digital media platforms primarily. You will see that the content includes lots of descriptions on what I would call legalese translations. Because again, we try to not lean on the notions that the public understands some of the terms that we more frequently use. And we are also including calls to action and public education points in our materials. It's a solid formula that we have adopted. We will also be sharing our material on regular messaging services such as WhatsApp. We have converted a lot of our material into Spanish in the initial stages, and we will be branching out to other secondary languages such as Mandarin, which we have found comes up quite frequently, especially at our district courts. Another key component of the project is the development of a suite of self-paced online training modules and supplemental resources for judges, judicial officers, court staff, called Working with Litigants in Person. These are the 4 modules, and we will give you a quick sneak peek. I'm not sure if you can hear it.
We will replay the video.
Welcome to Working with Litigants in Person. This training is brought to you by the Judiciary of Trinidad and Tobago. This is Module 2, Handling Courtroom Proceedings with Litigants in Person. The purpose of this module is to provide best practices and strategies for handling courtroom proceedings with self-represented litigants or litigants in person, LIPs. After completing it, you should be able to better understand the judge or judicial officer's role with respect to litigants in person, recognize challenges litigants in person may face in the courtroom, understand courtroom management strategies that judges and judicial officers can employ when adjudicating matters involving litigants in person, and identify strategies for judges, judicial officers, and court staff to support litigants in person in understanding and participating in court matters.
Thank you. And so these training modules are available on a platform that was also developed in partnership with the National Center for State Courts called Just Connect, and is available not only within Trinidad and Tobago, but to judicial officers and judges across the Caribbean region. Last slide. Basically, and ultimately, our broader goal is to ensure that we provide support at every step along the customer's journey, from the time a conflict occurs to initiating a court case before the courts, interacting with the court office, going to court, and having their hearings, as well as receiving court orders and directions. We've made some headway, but there's much work to be done, and I'm grateful to have certainly learned a lot from my colleagues here at this conference. We're working towards other development, including simplifying court forms, orders, and directions, and the use of AI-supported tools to assist customers with document preparation and presentation before the courts, to name a few. Last point is that our early engagement of justice sector stakeholders allowed us to receive their commitment to support us in disseminating material as well. And so we will garner additional reach through their platforms and their efforts as well. And so I go back to Joanne.
Thank you so much, Shauna, and I do realize that we're out of time, but I'm going to ask that we be indulged for just a few more minutes. And by now, you know I'm the video person, right? I'm the co-presenter. So I'd like to play this last video for you, and it really does speak for itself, and then we can just have just 1 more minute discussion.
On what grounds should an ex parte Maddie Boyd be considered?
Your Honor, Ms. Russell has failed to legal, and she's legally legal. We asked the court to legal.
I see, and that's legal.
Very legal.
Ms. Russell,
I'm sorry, Judge, I don't understand.
Commissioner. I'm not a judge, I'm court commissioner, and I asked you what your plan is.
My plan.
To provide for Maddie, you removed her from her home in the middle of the night, have withheld and concealed her whereabouts from Mr. Boyd for more than 72 hours, and have neither a home nor income. What's your plan?
I'm figuring that out.
Do you have a roof over her head?
Yes. We're currently at McMullen House.
That's a DV shelter.
Yes. We were referred there by social services after I told them how unsafe it was.
Your Honor, this is completely out of left field. My client has never laid a hand on this woman or his child.
Miss Russell, did you file a police report on the night you left?
No.
Do you have any third-party witnesses to confirm this allegation?
No.
Have you ever filed a police report at any time documenting the domestic abuse of Mr. Boyd?
No.
Your Honor, may I throw some more legal at you?
Yes, legal means.
She failed to legal, which is legally illegal per legal.
Miss Russell, is this true? You were in a car accident with Mr. Boyd's child in the back seat unattended.
Yes. I was looking for a mermaid.
Mr. Boyd, the court grants your emergency petition for an ex parte order to return Maddie to your custody. We will reconvene in 7 days.
So thank you. Again, the video speaks for itself. I wanted to play this video because I think we all need to empathize. We all need to really look at the faces of the persons that come to the court for service. And I hope that for just a few minutes, we were able to do just that. In order to earn the trust and confidence of the public and to safeguard the hallmark principles of the administration of justice, courts must embody empathy, courtesy, competency, and fairness, while balancing impartiality and neutrality. These are not mutually exclusive. Our respective citizens deserve no less from our justice system. Thank you.
Thank you very much, Joanna and Joan. Really very interesting presentation. The first video after having lunch at this stage of the meeting was very healthy. We had the opportunity to laugh, to smile, and the last one really very interesting to empathize, and the images were so strong. Finally, it's very interesting the developing tools that you're taking in Trinidad and Tobago to support the self-represented issue, the programs of SAFE and the blueprint, and the importance also of training, the guidance, all the materials that you share is very important. I was wondering about the lawyers, if they are part of the stakeholders, in the city of Buenos Aires, where we're still pending the developing of the neighborhood justice. In Spanish is justicia vecinal, is a constitutional law that we have to develop. When the different projects are raised up in the legislative branch, we have most of the projects have the self-representing issue and the lawyers are making lobby not to have this kind of justice. But finally, you will agree with me that this kind of process of justice is a high quality justice in a very quick stage of the process, in informal process, and finally sustainable judge decision. Thank you very much for sharing your presentation. Now is the turn of Alexander. Alexander Woon is a Singapore qualified lawyer whose practice focuses on criminal law and legal technology innovation. He is currently Provost Chair at the Singapore University of Social Sciences School of Law. Alexander was previously Deputy Director on the Office of Transformation and Innovation of Judiciary. He was part of the team overseeing transformation efforts across Singapore's judiciary, comprising the Supreme Court, state courts, and family justice courts. In such capacity, he was involved in legal strategy and law reform initiatives, culture and capacity building for legal innovation, and development of the legal tech products. Prior to that, Alexander was a Deputy Public Prosecutor, State Counsel with the Attorney General Chambers, Financial and Technology Crime. He prosecuted a wide variety of crimes, including corruption, white-collar crime, technology crime, intellectual property crime, and homicide. Alexander holds a Master of Law degree, Distinction Dean's List, from Georgetown University Law Center, and a Bachelor of Arts in Law with honors from the University of Cambridge. I was talking before he did so many things with only 34 years. Congratulations, Alexander. The floor is yours.
Well, thank you very much, Judge, and thank you everyone for having me here. My talk, I think, today is going to be a bit about mindsets, really. I think part of the problem with access to justice is this. We design our legal systems first. We optimize them first for ourselves, for lawyers, for judges, for court administrators, whatever it may be. And then we think about how do we translate that for ordinary persons who are unrepresented. I think that's a problem. There are two kind of modes or ways in which we can approach this issue. The first is what I call translational, which is what I have just described. We build the thing first and worry about how people are going to use it later. So we devote a lot of our efforts to translating what is inherently a complex system into something that we think is simple enough for self-represented persons to use. But the second approach, and I suggest it's something we should consider quite earnestly, is what I call a transformative approach to access to justice, which is that we should bake in the usability of the processes into our design. We should think at the first instance, how are people going to use this? And not simply optimize for lawyers and judges and court administrators. And that is why I've called my talk here Inverting the Model, because very often I think we are not user-centric. We are, well, I suppose, I don't know what quite the correct term would be, UZ-centric, I suppose. The people who are, we are centered on the people who are delivering the services, and not on the people who are consuming the services. So here's what I'm going to talk about today in the 15 minutes that I have available to me. 3 points, right? What is the role of courts? Why do people represent themselves? And how can we better help these self-represented persons? I will suggest to you that access to justice is the point of courts. Right? That's why I'm starting with what is the role of courts. Right? And one of the things that I'm going to say at the end of this talk, which may be surprising, is we should think about justice as a product, justice as a service. A product is no good. It may be the best product in the world, objectively speaking, whatever that means. But if no one's using it, it's a bad product. If the people who are supposed to use it think it's a bad product, it's a bad product. And I think we should start thinking about who do these legal rights and obligations belong to? They belong to ordinary people. And if we're really thinking about effective access to justice, it's those people that need to feel like justice has been done. I'll say that again. It's not enough, I think, that justice is done according to what we as legal professionals think is justice. The people who are receiving those legal services must feel that justice has been done as well. I think that's the important part. I'll just skip over this. What is the role of courts? So our Chief Justice has recently said this. that the courts have two distinct but complementary kinds of roles. The first is the adjudicative role, to interpret and impartially apply the law in each case. And the second, which I think is a little bit more novel, is the systemic role. And this is what the Chief Justice said, by which I mean its task of developing and operating a system for the administration of justice that is accessible to all and meets the needs of all. It is by discharging both these roles that the court can secure public trust in our justice system and more broadly in the rule of law in our society. Now, if I may, with great respect, disagree with the Chief Justice, I do think that these are actually two aspects of the same thing. Legal rights and liabilities do not exist in a vacuum. They belong to people. They belong to real, ordinary people. The duty to adjudicate cases fairly, I feel, is an outcropping of what the Chief Justice has called the court's systemic role. It is all about delivering justice as a service to the people who have those legal rights and obligations. But that leads us to this, outcomes thinking. If the point of the courts is to deliver justice to ordinary people, well, we have to think about what ordinary people really want. And now I will have to take this chestnut from Professor Richard Susskind. It is, if you will bear with me, a little bit overused, but nonetheless, I think it is the best source for it. People don't really want courts or judges or law or anything like that. People want solutions to their problems. It follows that we shouldn't really be so obsessed with, well, this is the law, this is the procedure, this is the way we've always done things. We should be thinking about what's the best way to deliver justice as a service to the people who need it. And that leads me to my third point. What is the job to be done? I think we have a lot to learn from other professions, other industries here. We've seen a great growth in the quality and delivery of consumer products, consumer services. And one of the insights that we have in the innovation field, and this comes from Clayton M. Christensen's work, is this idea of jobs to be done. So this is what Clayton Christensen says. A job is a shorthand for what an individual really seeks to accomplish in given circumstances. But this goal usually involves more than just a straightforward task. Consider the experience a person is trying to create. The circumstances are more important than customer characteristics, product attributes, new technologies, or trends. Good innovations solve problems that formerly had only inadequate solutions or no solution. And jobs are never simply about function. They have powerful social and emotional dimensions. And this brings me back to my earlier point, that it is not sufficient that justice is done. The people who receive those services must feel that justice is done. I think that is one of the key insights that we have here. One of the themes that I'll come back to is sustainable outcomes. If people don't feel that justice is done, if they feel that they didn't get a fair shake, that's not good for anybody. They'll keep appealing, they'll keep coming back to your system, they'll overburden it. That's the practical ramification. And the political and social ramification is your judicial system might start to lose legitimacy. That is something our Chief Justice emphasized before. Discharging those two roles is key to maintaining the legitimacy of the institution of the judiciary. So I think it's not just about feelings. Some of you may say, well, that's just fluffy stuff. What have feelings got to do with it? Fundamentally, people who consume legal services have no objective metric for measuring the quality of the services they received. All they know is whether they feel that justice has been done or not. This brings me to my second point. Why do people represent themselves? And here's the short answer. I'll give you the long answer, of course. All right, 3, lawyers are hard to access. The system is set up that way. And look, let's not forget, it's their right. Yeah? Lawyers are hard to access. This is a snapshot from the World Justice Project's Access to Justice survey in 2019 for Singapore. Look at that. Sources of help. 31% were able to access help. 31%. In a country as prosperous as Singapore, 31%, that's not a great figure. All right? And look at that for type of advisor. 53% are looking to family and friends for legal help. And only 29% are getting advice from lawyers or professional advisors. All right? So here's why. And a little bit of this is from personal experience. People don't necessarily know what constitutes a legal problem. They don't understand what constitutes a legal problem. If I may deviate into an anecdote, I was once at a community sort of meet the people session, and an old man came in and said, look, my son is not paying for me, right? My son is not helping me with my cost of living expenses. And in Singapore, we have a legal mechanism for dealing with that. It's called the Maintenance of Parents Tribunal, right? But the volunteer just gave him some food vouchers and told him, okay, here's some food vouchers. And I said, look, why didn't you tell this man that he had a legal remedy? And the volunteer was just sort of like, no, right? And the poor man didn't even know that it was a legal problem. He didn't understand that it was a legal problem that he could have gone to a lawyer and gotten some legal recourse for. But more than that, people don't know how to find good lawyers. They perceive legal services as expensive. And importantly, they perceive legal services as intimidating. Going to see a lawyer is worse than going to see the dentist, right? It is an unsettling experience for most people. And they don't know where to start. They don't know where to start. That's why periodically I'm also involved in legal tech. A lot of people come up to me and say, hey, let's build an Uber for lawyers. And I don't have time to go into the many ways in which that is a terrible idea. But the fundamental point is it's very difficult to figure out who's a good lawyer. Remember what I said earlier. Lay people fundamentally don't have any objective metrics for determining the quality of legal services that are administered to them. The system is actually set up that way, right? The system is actually set up that way. It's a funnel. We don't have publicly available data on this, and that's something I hope we will work on in this jurisdiction. But my suspicion is that the majority of cases in the legal system don't involve lawyers at all, right? For instance, there's a whole bunch of tribunals, like the Small Claims Tribunal, the Employment Claims Tribunal, Community Justice Tribunals, where lawyers are in fact not allowed. These are for what we as lawyers would consider low-value, low-complexity cases. But of course, by their very nature, these form the bulk of cases, right? Most cases are simple. Most cases aren't complex. And then there's a whole group of low-value cases where lawyers are allowed, but they're not cost-effective. My background is in criminal law. And I dare say, again, I don't have publicly available data to back this up, but I dare say that in a majority of criminal cases, you will be facing a self-represented accused person. And that's because the majority of criminal cases are, again, not complex. They are simple. Regulatory cases, littering, traffic offenses, things like that, where even if you could theoretically hire a lawyer, it would not be cost effective. You go to court, you represent yourself, you come away with a fine, maybe a few $100s or a few $1,000s. You go and engage a lawyer, immediately you're going to be paying a few $1,000s. It doesn't really make sense to engage lawyers in those cases. And I dare say in many civil cases, in many family cases, the situation is the same. Even if you can theoretically bring a lawyer in, it may not be cost effective to do so if the value of the claim at stake is relatively small. And that's not necessarily a bad thing. We wouldn't want to overcomplicate cases, and of course, from a systemic perspective, you would want this funnel. You would want to divert cases that don't really need to be that complex away from lawyers and from courts and so on and so forth, and to tribunals and things like that. But finally, it's their right to represent themselves, and I don't think we should forget this. Legal rights and obligations belong to everyone. They belong to ordinary people. There is no obligation to obtain representation, at least not in the common law tradition, and I don't think there should ever be an obligation put on ordinary people to obtain representation as a minimum requirement for obtaining access to justice. I think just as a fundamental moral principle, that should be something that we should agree on. But here's the thing. Practically speaking, there will always be a sandwich class. There are those people who will qualify for legal aid, and there are those people for whom, yeah, we can pay for lawyers, no problem. But there will always be people in the middle who are rich enough that they do not qualify for legal aid, but not so rich that paying for legal services doesn't just hurt a lot. And that's the problem. Therein lies the problem. You can keep changing the boundaries for legal aid, sure, you can change the threshold and so on and so forth, but you'll never completely eliminate the problem of this sandwich or middle class, unless for some reason you give universal legal representation, which may not be financially, economically possible. So no matter what we do, I don't think we can get away from this irreducible call of people who will need to represent themselves, no matter what. Which brings me to this point. So how can we help them? I hope by this point I've convinced you that it is a practical and moral imperative to look out for the well-being of self-represented persons. Let me make 3 points here. Well, I think we should adopt a framework of user-centric design. We've seen this in commercial product design, right? Things like your iPhones, for example. Very well-made piece of technology. It's a complicated piece of technology, but is it complicated to use? Not really. It's very easy to use because the design is good. The design is good. You don't need to be an engineer to use an iPhone. And we've seen some of this happening in certain places in the world. So in British Columbia and Canada, they have the Civil Dispute Resolution Tribunal, which was very interesting. They built this tribunal from the ground up for self-represented persons. As it was explained to me by the former chair, Shannon Salter, they do things like they hire hospitality-trained staff to staff their counters. Not paralegals, hospitality-trained staff, because they understand the job to be done is to reassure people who are coming in. They make sure that all their documents are written at a 6th grade reading level, because that's the average level of reading in British Columbia. Fascinating, right? We've seen some efforts in the US as well. So Stanford University has a legal design lab. Suffolk University has a project called the Document Assembly Line, where they've gone through and they've looked at things like court forms and tried to simplify these things radically for people who might be using them. Which brings me to my final point on this slide. What we really need to do is create a hierarchy of user needs. Rather than, as I said, designing something that we as lawyers and as court administrators think is good and then translating it, we need to start thinking about putting the needs of self-represented persons first, right? And judges are respected public servants. They perform a important role in society, and obviously we should respect them and should respect their time. But we shouldn't always do this at the expense of self-represented persons. We should be thinking about, look, how can we design this? How can we build this in such a way that the recipients of the services, right, are the ones who come out feeling like they've had a good experience? And yes, of course, we can make certain trade-offs for judges and lawyers along the way. But I do think we need to invert that model. Quite traditionally, we have been thinking in the common law world about what is convenient for the judge. In his courtroom, the judge is the final say. Everything must be judge-oriented. But what if we were to invert that model and think about how we could make the process useful for litigants in person, right? A hierarchy of needs. Self-represented persons versus judges second, and lawyers last. My colleagues in the bar will not thank me for this, but they're paid for it. That's their job. So I'm not terribly concerned about them. All right? I mean, they're there to reduce friction, right? That's the job. I do need to speed this up. Addressing pain points. As I said, if we adopt a product mindset, we're looking at addressing pain points for SRPs. One of the things that we need to do is figure out how to humanize interactions with the law. So Pro Bono SG, our main pro bono organization, has created a service center, and they put it not in an official government building, but it's in a temple in one of the heartland areas in Singapore. Very interesting. Why? Because, again, they figured out that people find law to be very intimidating. If you put it in a setting that makes it easier for people to physically access, that improves access to justice. Another thing that we can do is we can streamline processes. Processes don't help anybody, right? Processes just make things more complicated. Maybe we can help people. One of the things the Singapore judiciary did during COVID was to expand our remote and asynchronous hearing offerings, which is great. This is especially useful for people who can't spare the time to come down. People who, for example, might even be witnesses in court proceedings. Very often it's difficult for them. If you're a construction worker in Singapore and you're subpoenaed to come to court, that's very disruptive for you, and your boss is not going to be very happy about it. Anything that we can do to make it easier for these people to come to court is a good thing. And the last point here, eliminating unnecessary complexity. There will always be an irreducible core of complexity because life is complex, legal disputes are complex. But there's also a lot of unnecessary complexity. And we shouldn't be afraid of slashing that. To give a somewhat trivial example, in Singapore, we maintain the common law distinction between swearing an affidavit for Christians and affirming an affidavit for non-Christians. And once I went to get an affidavit done, and accidentally one of my pages had affirm instead of swear, and I had to go back and get the whole thing done again. Now, that's not a big deal for me. Fortunately, I was working in the courts at the time, and to me, the monetary cost was affordable. But to someone else, it could have taken up a whole day. They might have had to take leave to go back and get it redone, and they could, and the cost might not have been incidental to them. Does it really make a difference whether an affidavit is sworn or affirmed? I suggest to you that it doesn't. These are the kinds of complexity that we can eliminate without any harm to our legal system, and that might considerably improve the experience of users of that same system. Which brings me to my last point, justice as a service. I suggest again that we adopt a product mindset. We are delivering a service to people. They are not paying for the privilege of coming to us. And if we think about that, we should think empirically. We should think about who is going to use this system the most? Very often, I think, when we design legal processes, at least in my experience, it's all lawyers in the room. It's all lawyers in the room, and we all think like lawyers. But we don't seem to realize that maybe we are not the majority, right? Maybe we are not the people that use these systems most. And therefore, we should also move into a more agile service development and delivery kind of model. Rather than taking a long time to amend court processes and rules and things like that, maybe we should start thinking about sandboxing, smaller test pilots and trials. Things like the British Columbia Civil Dispute Tribunal set up a new court, try something there, or even in Beijing, where in the Beijing Internet Court, they have built an entire new building, literally from the ground up, specifically for internet courts. Maybe that's one way that we can improve service delivery, by trying things out faster, being a bit more agile, a bit more willing to learn. And that leads me to my next point about multidisciplinary collaboration. Maybe it shouldn't just be lawyers in the room when we are designing court processes. Maybe we need to start bringing in people like user experience designers. Yeah? Maybe we need to start bringing in people like psychologists and counselors. Yeah? And that leads me to my final point about sustainable outcomes. Again, if we go back to thinking about what the courts are doing, it is delivering access to justice. I believe that is the fundamental purpose of the courts. People have to feel like justice is done. We've seen this in the Singapore courts and the family justice courts. We now have this philosophy of therapeutic justice, making sure that the outcomes are sustainable, that people feel like this is a fair decision. Litigation very often is one loser, one winner, and the loser may go away feeling like, I didn't get a fair shake. If we move towards this outcome thinking model for all our courts, not just the family justice courts, I believe that actually increases substantive access to justice as well. And that's it. Thank you very much for listening, ladies and gentlemen. Have a great day.
Thank you very much, Alexander. Really very interesting, your presentation, the inverting the model, and you made the approach of the social and emotional dimension. That was really amazing, no? Also, this point that you raised, that people must feel justice. They want to feel it, that finally it happens. And permit me to say you that in your presentation as the SRPS models, maybe in the next presentation you can add what is happening in Argentina with Justicia de Paz in Spanish. That might be the translation, peace justice. You might know that Argentina is a very huge country. Most of you must know or must heard about the Patagonia, just as an example, no? In Buenos Aires, we have 3 million people living, another 3 million coming in the city every single day. But in the Patagonia, it's so huge piece of land with some cities, but people living abroad the cities and having the necessity also of judge. And there we have judges that they are not even lawyers. They are not lawyers. They are social leaders that they are choosing. The jurisdictions have their own models, but they are chosen maybe by the governor. And they are very prestigious guys. People trust in that kind of judiciary that has almost the model that the three of you introduced today. No? They have also the possibility of dialogue solutions that, as we were speaking today and yesterday as well, they are solutions that are sustainable in time, that they have another dynamic of the traditional role of justice that is adjudicative. No, you have the reason, but he has not the reason. The dialogue solutions are solutions that permits that the conflict does not scale to a crime level, let's say. So that is what happened in Argentina. This kind of Justicia de Paz, peace justice, is very prestigious, and finally is fostering the trust in judiciary. You were very, very good, excellent presentation, the three of us. Thank you very much for sharing your thoughts and your experiences. Thank you.
All right, and can we give our moderator a big hand as well? Thank you so much, Judge Otamendi, for moderating.